talk about one thing because it relates to this special needs issue. Now, this might not seem relevant to a lot of you that don't have any special needs children or grandchildren, but I do want to raise this because this is a significant change in the law that gets a little bit technical. So I just want you to know that it's out there. It's a little bit of a technical issue, but for a generation or maybe a couple generations, it's been well accepted that if somebody wants to leave money, or if a person with special needs has money, that money can be set aside into a special needs trust, and so that it can be protected for them, and that they can still qualify, for example, for medical benefits, or Medicare, for example, or disability through Social Security and those types of things. Well accepted, and it's still well accepted. Social Security Administration is getting really, really picky about those things. So what folks like Jennifer and I used to do, and Jennifer's really getting more and more focused on the special needs part of things. So the younger folks that need special needs trust, but for a couple generations, we give examples of what this money could be used for. So in the trust, it could say, this money could be used for this money could be used for that, this money could be used to have my daughter go on a vacation, and she can't go by herself, so it would also pay for a companion, okay? We give examples. Social Security Administration now saying that putting those examples in, you're invalidating the trust. But for years and years and years, they said it was fine. But a lot of those trusts aren't easily changed. And so the idea is, if you have a special needs trust, we might want to look at that. Now there's two, and this is where it gets really technical, so I'm just going to, if you have questions about it, just call us and we'll go through it. But there's really two types of special needs trusts. And I'm not going to get too technical and use the legal jargon, but I'm going to kind of tell you there's two types. There's the type that mom and dad or grandpa and grandma put the money aside for the special needs person, and then there's the type where the special needs person had their own money. Okay, the type where grandma and grandpa or mom and dad put the money aside for the special needs person, those really haven't changed that much. Those are the easier type, okay, where the individual that has special needs didn't have their own money, it was somebody else's money, okay? That hasn't changed that much. The type that's changed is the type that is where the person themselves has the money, okay? Why would they have money? Maybe there was a lawsuit because of a car accident. Maybe it was, maybe it was grandma and grandpa didn't do proper legal planning, okay? So if you don't have those provisions in there, and most of you would have those because you've worked with us, but if you don't have those provisions in there and you left them outright to a special needs grandchild or child, then the money's in their name, and now they're going to have to do this other more complicated type of a trust. And the other type, more complicated type of a trust, they call it a payback trust. And what that means is, if they don't use it up, they got to give it back to the state. Whatever's left over, they got to give it back to the state. So we don't like that type of a trust. So ideally, we're not leaving money to a special needs child directly, not outright to them. We're giving it to them through what we call first-party special needs, or a third-party special needs trust, which means grandma and grandpa are properly setting it aside for the special needs child, but it's not. It doesn't go into their name. Once it's in their name, now we got to go with the tougher trust, and it has all these extra restrictions now, okay? I know that was a long explanation for something that probably doesn't relate to a lot of you, but it's a significant issue that needs to be fixed for any of you that have that issue, okay? And if you have questions about it, call us. Okay, final thing on here is we bought new real estate. That's one of those things that, people tend to do. They say, okay, kids moved out, we're going to downsize, we're going to get a condo, we don't have to mow the lawn anymore. If you bought a condo, you didn't tell us about it, condo's not in the trust. What does that mean? Condo's going to go through probate. Okay? My general thought is, I don't want to go through probate. Okay? It's just, again, another thing where now the government's involved, lawyers and judges are involved, and we can avoid that by a simple deed making sure that your house is in the trust. Okay, we're actually going to go through that next. What does that mean, house is in the trust, bank accounts are in the trust? What does it mean to say they're in the trust? Now, most of you know what I'm talking about, but some people still think it means that the typewritten section of the trust has to name the house, or it has to name the bank account. Well, that wouldn't work very well because bank accounts change, right? Banks change. Like Citizens Bank is now First American Bank. So if it mentions a Citizens Bank account, well, that's not very helpful to name it. It's actually the account that names the trust. Okay? So on the account, like Jennifer said, when you get a statement in the mail, it would say your name, and then it would say trust. And that's one of the best ways to figure out if it's in the account. Now, we had a woman So back a few years, but she'd been a client for years, and we made sure that her accounts were in the trust. She went to the credit union, and they said the accounts were in the trust. Her illness was one that she kind of had warning. Our daughter called us and said, "Mom's not going to be with us much longer. Is there any last minute stuff I need to do?" So we went through a number of things, and if you know that, that's a good idea to call us. And so if there's last minute stuff, there might be not any last minute stuff we need to do, but it's worth going through that checklist to say, well, okay, let's check this, to make your life easier after Mom passes or Dad passes. So the idea is, she did call us. We sent her to, one of the things we did was send her to the credit union and say, just double check. They said it was in there, let's double check. She went to the credit union, and the credit union said, yep, we're all set, it's in there. Mom died. They said, oh, well, only one account was in there. Mom has 7 accounts. On that particular case, because we went overboard, we actually forced the credit union to say, no, we're going to account as if all of them were. Because we had confirmation, we had something in writing, we had all this other stuff, and they just didn't do their job. But we don't want to rely on that. We'd actually like to see something in writing, meaning the bank statement that shows that they're all entitled into the trust. Okay? All right. So this is, if you've came in to see us in the last, probably 3 years or so, you've seen some of these pictures. And I'm going to go through them one by one. But the 3 columns here are wills, regular revocable trusts, and then long-term care planning trust, what we often call the lockbox trust. Okay? And so most of you probably have a will and a revocable trust, and some of you may have a lockbox trust. And we're going to spend just a very brief time talking about IRAs and talking about the lifetime protector trust for the kids. That, again, some of you have, some of you don't. So let's start off with, this is getting complicated, right? And our goal, our slogan is keeping life simple. All right? Our goal is keeping life simple, and I just said it's getting complicated. So the point of this is to make it simple to use. Simple for you to maintain it. That's why we have these annual meetings. That's why we have Amy available to you. Simple to use, okay? Simple for the kids to settle. Simple for the kids to maintain if you're sick. That's in other words, simple results. It doesn't matter how complicated we get and how complicated the legal stuff is. So what I'm trying to do is bring you over into my world, and my world's pretty complicated sometimes, okay? So I'm trying to bring you over in my world today, but the idea is you don't have to know all this stuff to make sure that this is going to work properly. Like that whole special needs trust thing, that's complicated. You don't have to know that, you just have to know that we reviewed it and they said, yep, it's in there, okay? It's in there, pasta sauce, it's in there, right? And so if it's in there or not in there, it's in there, and now it can be simple again. But the point of this is, and I use this analogy, a lot of you probably heard me tell this story before, is, you drove here today, a few of you probably know how to, build a car from scratch, right? But most of us don't know how to build a car from scratch. And cars are getting more and more complicated. There's the commercial now where you can push a button and it'll parallel park for you. I can't imagine how complicated that is. But it's easy to drive, okay? The more complicated it is, the easier it is to use, okay? I have no idea how you engineer something that would make it so you can parallel park, but I know how to push a button. And that's what these are supposed to be. It's supposed to be, we make it more complicated so your life is easier, so that your kids' life is easier. So it's easier for you if you get sick, so that we have a plan in place. I'm going to go off on a tangent. I never do this, go ahead. But the tangent is this. We all have these stages in life that we all accept, right? So we're kids, we go to high school, we get out of school, we either go to college, we get a job, that's a transition. Maybe we get married, that's a transition. We have kids, that's a transition. We get a good job, that's a transition. We retire, we're a transition. We plan for all of those things. We plan for years for all of those things. When somebody's getting ready to retire, I hear people come in all the time and say, I plan to retire in 10 years. Great. They plan for all of those things. And then somehow we imagine that all of a sudden we're just going to float, peacefully for the rest of our life. I joke because financial advisors sometimes have these commercials or brochures where everything's so rosy after you retire, right? Everything's just so perfect. Everybody owns a vineyard and they're just, walking down the beach holding hands and they're perfectly fit. They're like fitter than I've ever been and they're in their 90s and it's just like, maybe I suppose that's possible, but then there's the alternative story. And I think most of us go to that alternative story. Most of us aren't going to own vineyards or be walking down the beach, jogging down the beach at age 90, right? And the alternative story is there is that last transition. Most of us are going to need care along the way, okay? You're going to see a statistic in a bit that says a good percentage of us are going to end up in a nursing home, and I hate that. And we try to avoid that, and we try to make that so that our clients never go to a nursing home, but have a plan in case they do, okay? But statistics say, why is that, by the way? Why is it that so many people go to a nursing home? Because they didn't plan for that stage of life. They didn't set it up for that stage of life. They didn't accept help when they needed it, okay? But they really don't plan for this stage. And so what do most people do? They end up having a crisis. Okay, dad passes and mom's living alone and mom has some memory issues or some dementia or something like that. And the kids just kind of, we're going to ignore this until a crisis happens, until the police get called or until there's a car accident, and we're just going to ignore this and look the other way. Or we could have had a plan for that. Now, it's very possible that you could live a long life, be very healthy, and die peacefully in your sleep without any major health concerns at age 102. That's very possible. But it's also possible that doesn't happen. And so what we're saying is you got to have a plan for that. And so when I say keep it simple, those plans get complicated, but it's simpler to have a plan than not to have a plan. It's simpler to have a plan for that than to have no strategy and just everybody, ignoring the issue and then wait till a crisis happens. Okay? That's what I mean by keeping it simple. All right. So let's go through this. We try to make planning for today, tomorrow, and 25 years from now, and that's just some date in the future. Planning should work even if changes occur in your life, things like that. One quick thing, control versus ownership. Lots of folks will come in and they do a whole plan because they want to make sure that their child or some trusted person has access. If I get sick, I want them to have access to my accounts. When I die, I want them to have access to my accounts. I don't want them to lock my accounts. So they want them to have control. First of all, we got to make sure we got the right person there. We don't want the child that is always borrowing money and never repaying it. We don't want the child who maybe has stolen money for us in the past or can't balance their checkbook. So we want somebody that is, organized, but we maybe give them control. We don't need to give them ownership. Okay? This is the fight that I'm fighting all the time with banks, lawyers, accountants, everybody else that says, oh, just put the kids' names on it. Or let's do a quick claim deed to add the kids' names to the house. Or those types of things. Giving them ownership is bad. Okay? Or gifting. Okay? People say, oh, I might go into a nursing home, so I'm going to start giving away $10,000 to each of my kids. Is that a good idea? It's exempt, right? No, it's not exempt. Okay? That $10,000 myth has nothing to do with the vast majority of us. If you have 5.4 million now, I think it is, then maybe we should do some gifting. But if you have less than 5.4 million, that whole $10,000 that you're supposed to give away every year has nothing to do with you. That only is a tax rule for people that have more than 5.4 million. And if you're married, 10.8 million. Okay? So people give that advice all the time. Accountants, lawyers, smart people, bankers, really smart people say, well, are you giving each of your kids $10,000 every year? No, don't do that. It's bad. It will affect you if you end up having to apply for medical benefits, okay? They will penalize you for it. There's not an exemption for $10,000 or $14,000. That's only a tax rule. Now, am I saying that you can't be generous and be helpful to your children? No, I'm not saying that. I am saying don't be too generous, okay? Don't give away more than you have. Don't give away more than you could make up the difference. There's going to be consequences for you giving away money to your children. There are consequences for that, meaning if we apply for medical benefits at some point, they will penalize you for that. That's okay. We can deal with that. So if your child really needs the money or you really want to help out, you've got a generous heart, okay, fine. But know that there's consequences, and make sure you don't give away more than half of what you have left over, because we're going to have to make up the difference if in fact you go into a nursing home or something like that. Okay, so just be careful. I'm not saying you can't be generous. I'm saying be careful. Okay. So control versus ownership. First thing is the will. Okay, everybody remembers I call the will a funnel. Why? Because it's a catch-all. You die, you own stuff, and only your name and doesn't have beneficiary names on it. What's going to happen to it? It'll get caught in the funnel. So you got a house, and you die, the house is only in your name, it goes through the funnel. What if the house is only in husband's name, and then wife survives? it goes through the funnel. Now, most of the time we have husband and wife on the same property, right? So that it wouldn't go through the funnel. But if it's only in husband's name, that house is probably going to go through probate twice. Once when dad dies, and then again when mom dies, because we had to go through probate to get it over to mom, and then we have to go through probate again to get it to dad. So our best answer is, let's not do that at all, let's use the trust. And we're going to talk about the trust in a second here. But the idea is everything that goes through the funnel is going to end up going through probate. So we're in probate court a lot more now because of significant changes in the law that have occurred in the last couple of years here, and I think we have some pretty good probate judges around here. I like the judge in Saginaw, I like the judge in Genesee County, I think the judge in Shiawassee County is great, I like the judge in Bay County, and if I never saw them again, it wouldn't bother me. And my point on that is, they're good judges, but if we don't have to have the government involved in your stuff, let's not have the government involved in your stuff. Let's keep it out of there in the first place, okay? With proper legal planning, we can do that. Now, sometimes, because of the nature of bad things happening to you, that is actually the best answer, is to get permission from the court. So sometimes the judge can authorize things that you can't even authorize for yourself, that the government won't do it until the judge puts the stamp of approval on it. So, okay, well, then sometimes it makes sense to go into court, and that's what we've been doing a lot lately. And we've had a great deal of success with the local judges, so that's been very helpful. But ideally, we don't want to go into court. So the next thing, I like to call the trust a little red wagon. Why? Doesn't work like a funnel. It's not a catch-all. So lots of folks come in and they've got the trust, okay? It's really a binder, but I call it a wagon. If there's nothing in the wagon, it doesn't work. So if you've been to one of my classes, you probably have heard me say, most trusts don't work. What do I mean by that? Most trusts, people still end up having assets go through probate. Why? Several reasons. Because they never put the stuff in the trust in the first place. They never put the stuff in the wagon in the first place. Or they did, and then they sold the house and bought a condo and never put the condo in. They switched financial advisors. The banks changed names. Whatever. Stuff happens. That's why we do this annual meeting, to remind you, has stuff happened this year? Because if stuff happened, then we'll go and do that. Now, how do you actually get it in there? So for a bank account, a lot of times you go down to the bank and say, I've got this trust. I want my account in the trust. I've got this little wallet card that Bob gave me that has my trust information on it. I want to make sure that this account goes in this trust. And they look at the card and they say, okay, I can do that. Or they say, well, I need more information. So they flip it over. Our phone number is there. We'll email them or fax them the document that they need to get it into the trust. Okay? So that's how you get it. It's not that hard. You just got to go down to the bank. Or you got to go online. So if you don't go online, that's why we have people like Amy. Or you got to call up the 800 number and have them send you a form. If it's a life insurance, an annuity, if you have a financial advisor, you can do that. If a financial advisor's unsure why we're doing this, then probably a good idea to have them call us. We got to talk about that in a couple minutes here. But the idea is, we're just retitling the account. To put it in the wagon, we just have to use that form that says, okay, now this bank account is in the name of George and Sally Smith, trustee of the Smith Family Trust, or whatever the title is, which would be on your wallet card. Okay. Now you may have two trusts, and we'll talk about why you have two trusts. A lot of people would assume you have two trusts because you have a trust for husband and a trust for wife. That's possible, but for most of you, if you're our client, and some of our clients have a trust for husband and trust for wife because of unique circumstances. But most of you, if you have two trusts, it's not husband's trust and wife's trust. It's the Little Red Wagon Trust and the Lockbox Trust. Okay? And we put some assets in the Lockbox Trust and some assets in the Little Red Wagon Trust. Why? And okay, you all know I made up these terms, right? There's no such thing as a Little Red Wagon Trust, and there's no such thing as a Lockbox Trust. These are just analogies or examples. And I always have to say, don't hide your money in an actual lockbox. Don't put your money in a gun safe or in a safety deposit box. That's not safe, and if you apply for benefits and you've hidden your money, they have a term for you. It's called a felony, okay? Don't commit felonies. I always joke that, I don't want to impose my personal beliefs on you, but I just say no felonies, Anyway. So the idea here is some of you have this, some of you don't. Some of you have come to see me after our previous annual meetings and said, I really like this idea of the lockbox. It's going to help us get veterans benefits. It's going to protect these assets from the nursing home. And I said, no. It's not for everybody. It's not something that it's going to work for everybody. So some of you, it makes a lot of sense, and we may have recommended it. Some of you may have come in 3 or 4 times asking for the lockbox, and every single time I look at it, and we'll look at it anew every single time and say, well, maybe this will make sense now because times have changed, things have changed. And for some of you, we just say, sorry, this doesn't make sense for you. There's a number of reasons why it might not make sense. It could involve family situations and where you are with just different relationships you have within the family. It could also be if all of your assets are retirement assets, pre-taxed IRA type assets. If 99% of your assets are retirement assets, we probably can't do the lockbox, which is a shame, but it is what it is. Okay, so that's why we sometimes say, even when you say, yeah, this is a great idea, I love to do this, you can't do it. But this would be a separate trust. And so some of you say, well, do I have that? Do I not have that? On the turn-in sheet, and I don't think I have one of those turn-in sheets. On the turn-in sheet, there is a section on there that talks about this, do I have a lockbox or trust or not? If you want and you're not sure, you can check, I'm not sure, or I'm interested in learning more, and it's this yellow sheet is the turn-in sheet. So you're not going to turn in the memory jogger. That's for your use. The yellow sheet is the turn-in sheet. And just to kind of spend a second going through this, put your name and information on there. If you haven't given us some email, I know not everybody does email, but if you do email and you haven't given us your email and you want to get on our email newsletter, feel free to do that. If you want a copy of today's presentation, we're putting it on DVD. We got this nice gentleman over here who's video taping this, and so we can get a copy. You can watch this again. And then the memory jogger. We just gave you a couple lines to kind of put some details, and if there's stuff written on those lines, it means somebody in my office will call you to discuss it with you, okay? So the memory jogger is, you take that home, but if you filled out anything on the memory jogger, you might want to let us know about it and let us know so we can talk to you about whether you need to make changes to your trust. And then we have, the Little Red Wagon Trust and things like that. So, but the long-term care planning, that's the one that says, have you already started your long-term care planning with the lockbox trust, yes or no? If we see that you don't have a lockbox trust, would you like us to contact you to talk about long-term care planning? Okay, so that's going to be, now it's probably not going to be Jennifer or I that's calling you. We're going to have one of our other really talented team members call you, kind of walk you through it, and then decide whether it's worth it to have you come in and meet with us, okay? And we'll talk about what that would look like and what options you have for coming in and meeting with us. But this is the idea. It's got different unique qualities depending on whether you're a veteran or not a veteran, what types of assets you have and things like that. But under certain circumstances, it can protect those assets from having to spend out to a nursing home. It can protect them so you can qualify for the, sometimes for a married couple, $25,000 a year from the VA to help pay for home care or assisted living. Okay. When we say nursing home, that sometimes also could help us qualify for at-home Medicaid benefits. Okay, at-home care. Now, that you have to have income, individual person's income. The person that needs care, their income has to be under $2,199 per month. And when I mean that, I only really mean pension and Social Security. I don't mean investment income, those types of things. So sometimes if we have a husband and wife and one worked and the other one didn't, the one that worked and got a pension might not qualify, but the one that doesn't have a pension might qualify. Or maybe you both qualify because you don't have a pension. Maybe you owned your own business or something, you don't have a pension, and all you have is Social Security. If all you have is Social Security, you're likely to be able to qualify for that nursing home benefit at home. It's called Medicaid, but you might qualify for home care at home. You'd have to be pretty sick to qualify, but you could qualify and keep you in your home, okay? Another way that we're trying to keep people out of the nursing home. I want to briefly spend a minute on this. Some of you have planning for the children, okay? Now, this is planning for the children after you die, not while you're alive, after you die. Some of you chose to do this, some of you chose not to do it. It was more expensive, okay? So some of you said, nah, it's not worth the extra cost for the legal fees. Some of you said, no, I want to do that. And so, yeah, so we protect the money for Susie, and our idiot son-in-law can't get a hold of it. Or if they get divorced, our son-in-law doesn't get any of it. Roger, who maybe had a business that failed, and he's got all these creditors and people that want money. Yeah, sorry, Roger. But the idea of this is making sure that the inheritance you give them isn't subject to divorce, isn't subject to lawsuits, isn't subject to creditors or predators or people that want their money. And then for Danny, maybe it's Danny doesn't handle his money very well, and we want to make sure that he only gets so much per year, or maybe Danny is also has special needs, and we got to make sure that he doesn't lose his disability benefits or things like that. And so there's different ways. We call them lifetime protector trusts. Basically, Susie can control her share of the money. She can do whatever she wants with it. She can invest it however she wants with it. She can take it out and commingle it with her husband if she wants to. Now, that's a bad idea. That kind of gets rid of the purpose of it. But you're leaving it up to her to decide. And so she may say, no, that's a good idea. I want to protect it. The only drawback for her is she can't commingle it with her other money. Okay? This is a concept. It's a good idea for some folks. It's not a good idea for other folks. Okay? If it's something that you haven't done and you are interested in saying, maybe I should add that now. Something happened with my family that maybe we do need extra. And then what if you have IRAs? Okay? This is the one thing that we got to talk about as far as putting stuff in the wagon. If we put IRAs or 401ks or qualified annuities, anything where we haven't paid the taxes on it, you can't actually transfer it to the trust during your lifetime. Okay, you can transfer it up to the trust upon your death, and sometimes that has some real benefits to protect your spouse. So you want to leave it to your spouse, but you don't want that to be subject to the nursing home. You can do that. So it can be transferred on your death. But the problem is, so you've got to know whether or not your trust has these stretch-out provisions. So the idea is, if you haven't paid the taxes on it, do you think when you die, the IRS is just going to say, well, Dad didn't pay the taxes on it, I guess we don't get paid because Dad died? No, IRS wants their money, right? And they're going to get it eventually. And so most of the time when Dad dies and he has an IRA, IRS gets all of their money at once. What's the problem with the IRS getting all their money at once? They get more of it, right? So you're going to be in the highest tax bracket. You're going to get 40% as opposed to maybe paying 10%, depending on what the kids' tax brackets are. So the idea is here we can stretch those out. Now, if your trust, so we do both types of trusts, and again, this costs extra, right? So some of you said, it's not worth it for me to have these provisions in the trust. I'm just going to leave it up to the kids to make the decisions about whether they want to stretch out these IRAs and pay less taxes on them. If you left it up to the kids, do not list the trust as the beneficiary on these types of accounts. If these provisions, the stretch-out provisions, are in your trust, then we would list the trust as the beneficiary. Usually we list the spouse as the primary beneficiary and the trust as the alternate, unless your spouse is very sick, and then maybe we do a separate trust for the spouse so that the IRA can go into the trust and be protected for the spouse's long-term care needs. Okay. I'm going to spend a minute going through this binder here. So this is an example binder, and most of yours are going to look something like this. And so I'm going to kind of juggle it here. So most of you have a CD that has all of your signed documents on it, a digital copy of all your signed documents on it, and it should be in the front cover. Okay. If you don't have that, we'd be happy to make you a copy. You just have to call us, right? And then we have some instructions. Typically, you start off with a red page that say you got to put the stuff in the wagon. This does not work if you don't put it in the wagon, so that's really important. Then we have the trust itself. Okay. Yeah, that's a good idea. So we have the trust itself, usually in the next tab. And the trust itself, I want you to, when you're at home, and if you're looking at this video at home or things like that, I'd want you to turn to Article 4 of the trust, and that's where it has the distribution language. Who gets what when you die, okay? So if you want to change that, this is the annual review type of a thing. You want to change who gets what, you want to look at it and see what it says, okay? If you have specific bequests, in other words, you say, Johnny gets the house, that's going to be at the end of Article 3. So specific bequests are at the end of Article 3, and the regular distribution, full distribution, is in Article 4. If Article 4 is very short and only has a few sentences, then you do not have these. If Article 4 has several pages and it says, well, this is what happened to Johnny's trust, this is what happened to Roger's trust, this is what happens to, then you probably have those umbrellas. So there'd be a separate trust for each child. Okay. Article 11 or 10, I believe. So if you have an article that says retirement assets, then you have this in there. If you don't have an article that says retirement assets, then you do not have that in there. It's usually going to be Article 10 or 11. But it varies a little bit, so depending on if you're single or married and things like that. But the article would be titled Retirement Assets. Okay? Okay, so then, oops, sorry. Then we have the next section is the certificate. Okay, and so they might be in different orders. Jen and I have debated about what should come next in the binder and things like that. But in theory, there should be another document, usually in a plastic little folder that says Certificate of Trust. That's the summary of your trust. That's really all. That's the operative document. That's what you take to the bank. That's what you give to the financial advisor. You don't need to give them the whole trust. You just give them that 2 or 3 page summary.